Hello, my name is Nicky Touw and I'm a PhD candidate at the Open University. In my research project, I focus on fact-finding in so-called foreign direct liability claims. In this short lecture in the Sector Plan Business and Human Rights lecture series, I will provide for a more introductory exploration of the use of foreign direct liability claims and their place in the field of business and human rights. Questioning the impact of European developments on the debates. A lot of great work has been written about this topic and it is impossible for me to touch upon all relevant aspects. For further reading and as a reference to the sources that I draw from, I refer to the reading list that is provided together with this lecture. Let us start by explaining what foreign direct liability claims actually are and why they are being used. When you are watching this, it is very likely that you will have heard stories that go approximately as follows. A multinational enterprise, active in, let's say, the energy or natural resource food or clothing industry, has its headquarters in countries like the US, Canada, the UK, the Netherlands. Its supply chains, however, span across the globe. It builds an oil pipeline in Colombia, uses the work of factories in Bangladesh, or operates a gold mine in Tanzania. And then something goes horribly wrong. The clothing factory collapses while workers are inside, or the security forces that protect its mining operations use excessive force against protesters opposing the mining project. So the workers or protesters that get hurt when things go wrong seek compensation for their losses. But who can they turn to? The problem? The state is one of the investors in the mining project, or the subsidiary that owns the mine has no money because it was paid as dividend to its parent company. And the parent company says that it was not involved in the wrongful acts and that its subsidiary is an independent company. The conclusion? After both judicial and non-judicial actions, workers or protesters remain empty-handed for years. In many of these stories, it is said that running out of options in the host state has caused people to also focus on judicial actions in the home state of the multinational enterprise, resulting in the rise of foreign direct liability claims. In short, I understand foreign direct liability claims as being private law cases aimed at holding one or more entities of a multinational corporation liable, often the parent and the subsidiary, for harm that is caused to third parties and that amounted to an infringement of their human rights, while the claim is filed in a jurisdiction away from where the physical damage occurred. Or, as the title of the book edited by Greg Scott suggests, these claims frame torture as tort. The use of foreign direct liability claims is often said to have originated in the United States. In the 1980s, the use of the Alien Tort Claims Act gained in popularity because the statute reads that American district courts can assume jurisdiction over civil actions initiated by aliens for torts committed in violation of the law of nations or a treaty of the United States. And this statute was therefore deemed a hopeful avenue starting in approximately the 1990s for civil actions against either or both the subsidiary and the parent company for their contribution to human rights violations anywhere in the world. Albeit other causes of actions are explored as well, the Alien Tort Claims Act turned out to be much less effective than hoped by the advocates of foreign direct liability claims. The interpretation of the Act by the US Supreme Court in cases like Kiobel, Jester and now also Nestlé limited its scope and applicability dramatically, and some even say that it is now a dead letter. But it is important to understand that the use of foreign direct liability claims did not remain limited to the US courts. There are examples in, amongst others, Canada, South Africa, as well as a number of European countries. Looking at European cases specifically, the common rules on international private law have given foreign direct liability claims some distinct dynamics in Europe, and I'll mention two. First, whether a court can have jurisdiction over the case depends heavily on the existence of a case against the company that is domiciled in the country where the case is being filed, often the parent company. So as a general rule, currently in Article 4.1 of the Brussels I recast, European courts have jurisdiction over a tort claim in the domicile of the defendant. If jurisdiction is established over the anchor defendant, according to the current Article 8.1 Brussels I recast, courts can also have jurisdiction over defendants residing in other European member states if the cases against the different defendants are so closely connected that it is expedient to hear them together. A number of European countries have similar kind of rules in their domestic law that apply to foreign defendants not domiciled in member states. So, depending on domestic rules, a court may also assume jurisdiction over foreign defendants outside the EU. Second, the material law that will be applied in foreign direct liability claims will in general be the law of the country in which the damage occurred, as is prescribed by the current Article 4.1 of the Rome II regulation. The procedural rules applied will be those of the country in which the lawsuit is filed, however. So let's make this more concrete by taking a look at a recent judgment in the Netherlands that has been described as groundbreaking. In January 2021, the Hague Court of Appeal assumed for the first time a common law duty of care of a parent company over its subsidiary in one of the cases against Shell in the Netherlands. And I will get back to this liability issue later, but let's first look at the process itself. So the cases were filed by and on behalf of communities living in different villages in the Niger Delta, Nigeria, within the vicinity of Shell operations. So due to oil spills from pipelines operated by the Shell Petroleum Development Company, which I will refer to as SPDC, large areas have been polluted. And this pollution affected and still affects the livelihoods of the local communities. And reports show how important human rights like the right to food and health and a healthy environment are violated because of that. So the case against Shell, that was first initiated in 2008 in the Netherlands, concerns claims for damages and remediation, both against SPDC, the Nigerian entity, as well as against the parent company, Royal Dutch Shell plc, which I will refer to as RDS. Older but very similar rules to Brussels I recast and Rome II were applicable. So here, RDS is the so-called anchor defendant, domiciled in the Netherlands, and according to Dutch domestic law, SPDC, a foreign entity, can be involved in the claim because of the close connection of the claims against RDS. So the defendants argued that the close connection was missing and that the claim was an abuse of law because the claim against RDS was obviously without any real chance of success. The court and the Court of Appeal dismissed these arguments and the case could continue. So as for the applicable law, not much of a debate arose. So the parties agreed that this should be a Nigerian law. Based on the colonial history of Nigeria, this meant that English common law could be applied, including current English case law. But the court also applied specific Nigerian statutes like the Oil Pipelines Act. So what is interesting is the question when something is procedural and when material law. Nigerian law does not allow for a representative action, such that one of the plaintiffs, Milieudefensie, would not have had standing in the case. The court ruled, however, that here Dutch law should be applied. Also in respect of the burden and standard of proof, the court needed to explain its application. In principle, the Dutch standard would apply unless Nigerian material law would prescribe a specific division of the burden and standard of proof. Before sharing some reflections on fact-finding and liability in the case, let's look at three general debates that I believe are important to the use of foreign direct liability claims and their place in the field of business and human rights. So, because while their use has been on the rise, foreign direct liability claims have also been problematized for different reasons. First, The extraterritorial dimension of foreign direct liability claims has prompted a debate about the level and appropriateness of their interference in the sovereignty of other states. Indeed, the stories of foreign direct liability claims are often narrated in such a way that it appears as if the host state is incapable of rendering justice for victims of corporate human rights violations due to weak governance and judicial systems, but also a lack of regulation of corporate conduct in general. It is thus said that if home countries adjudicate on these cases and would find the subsidiary liable, they will to some extent prescribe how a host state needs to regulate the corporations that operate on their soil and as such will mingle in a political domain of another state. Some therefore argue that foreign direct liability claims amount to a violation of non-intervention or in foreign relations more generally, while others say that it is allowed, and some even argue that it should be applied. So without going into this specifically, since it would require a deep dive into the different types of jurisdiction on the public international law, I want to point out that the notion of extraterritoriality itself is important to discuss in the field of business and human rights. So extraterritorial adjudication is said to take place when a court decides on conduct that took place in another state, with the plaintiffs being from that state as well as the company. In the Shell case, the Nigerian entity SPDC. So the cases in Europe will, however, target the parent company as well, and in respect of those, they are said to only have extraterritorial implications instead of direct extraterritorial effect. And it is good to mention that the latter is also applied when specific home state laws target the parent company, also for actions in respect of their subsidiaries. So to what extent is this desirable? A more critical view of foreign direct liability claims argues that they have a counterproductive effect and actually maintain a problematic status quo. So first, the extraterritorial interference that I just described is claimed to be a form of neo-colonial domination, since most of these cases take place in the global north while the damage occurs in the global south. By adjudicating on conduct taking place in a host country, the home country still asserts power over former colonies. On the other hand, opponents of this critique also argue that this neo-colonial argument can be misused to shield, especially the parent companies and as such global north countries, from having to assume any liability or accountability at all. And this in and of itself could also maintain a neo-colonial status quo. A more extensive critique put forward by Grietje Baars specifically, but maybe also general critiques of human rights against human rights rhetoric, is that foreign direct liability claims may even necessarily cause the reinforcement of corporate power, because these claims use the very system, the law, which is said to have allowed for systematic injustices to happen in the first place. Without being able to go into this more, let's turn to a third debate. And this debate revolves around all the different barriers that plaintiffs in foreign direct liability claims face when filing them. The barriers that plaintiffs encounter range from, amongst others, a lack of clarity of legal standards, especially for parent liability, as well as more practical problems with the gathering of evidence and a general lack of resources to litigate the case. The effectiveness of endless litigation battles is of course questionable, and there are only a handful of cases with positive outcomes for the plaintiffs. There are slightly more out-of-court settlements that also resulted in some form of compensation. However, examples of a problematic distribution of the proceeds of these settlements are manifold. So based on this, some researchers argue that prevention or non-judicial mechanisms for redress are a more fruitful focus when aiming to remedy corporate human rights harms. Others argue, however, that the effects of foreign direct liability claims should not be measured on the basis of the outcome of the case itself alone. So in 2015, Judith Schremm-Sterling and Florian Wedstein, for example, argued that foreign direct liability claims also have an educational and regulatory effect. They found that the corporations involved in foreign direct liability claims, even if not found guilty, adjusted their human rights policies. Also, these cases may have a deterrence effect and as such regulate a broader range of corporate actors. In order to make this latter debate more concrete, let's again turn to the judgment against Shell. So the judgment against Shell is indeed groundbreaking because it is the first to assume this extraterritorial parent liability. However, it took over 13 years to reach this judgment and the action is ongoing. Some quick reflections on fact-finding and liability can illustrate some of the problems. So as a first of its kind, the Dutch Court of Appeal established the existence of a duty of care by the parent company, RDS, over its subsidiary, SPDC. It did so in respect of RDS for failing to apply a leak detection system to the oil pipelines near the village of Aruma. So the duty of care from RDS for applying such LDS system was established after a factual assessment of the interactions and relationships between the corporate entities, based on internal corporate documents obtained by disclosure. So the Court of Appeal cited Vedanta, one of the seminal foreign direct liability claims in the UK. Everything depends on the extent to which and the way in which the parent availed itself of the opportunity to take over, intervene in, control, supervise or advise the management of the relevant operations of the subsidiary. So according to the Court of Appeal, RDS had had such interventions as of 2010. Much remains unclear, however. The norm of parent liability leaves a lot of room for discussion about when a situation will actually amount to liability. And the test also shows the importance of fact-finding in these cases, which is what I research in my PhD. Without going into detail, but to highlight one aspect of the problem, this case also showed that the defendants were willing to resist disclosure of internal documents as much and as long as possible. A long process of disclosure took place after the Dutch court had ordered Shell to disclose a limited amount of internal documents. Rules on civil procedure might offer a wider range of fact-finding than has currently been explored. So given these debates on the appropriateness and effectiveness of foreign direct liability claims, as well as their continued use and evolving case law, where do we stand in Europe and where will we go? So I believe that recent legislative developments in Europe seem to show that these claims are now very carefully being endorsed by legislators as an important way to provide remedies to people whose human rights have been negatively impacted by the conduct of a multinational corporation. So as nicely mapped by the European Coalition for Corporate Justice, we see that laws and calls for action to implement mandatory corporate human rights due diligence is on the rise in Europe. And the developments and merits of this trend is discussed elsewhere in the lecture series. But what becomes clear when looking at the content of these laws and proposals is that at least a number of these new or developing laws include a civil cause of action. So currently in force is the French law on the duty of vigilance. So in case of a failure to comply with the duty of vigilance, the company, in line with the regular rules of tort liability, is obliged to repair the damage that would have been prevented if the company would have had an accurate vigilance plan in place. The action can be brought by any person showing an interest in bringing the action. So the proposal for a due diligence law by the European Parliament also includes that member states shall ensure that they have a liability scheme in place. It is explained that the proposal aims to ensure that undertakings can be held accountable for adverse human rights impacts and that anyone who has suffered harm in this regard can effectively exercise the right to a fair trial before a court and the right to obtain remedies in accordance with national law. So taking into account the considerations of the rules of private international law in the proposal, the initiators seem to have wanted to include the possibility of foreign direct liability claims as well. These norms and their exact meaning and application remain vague, however. Especially the connection between liability and the due diligence obligations remain to be seen. To what extent can due diligence measures serve as a defense, for example? Given that these norms remain vague and it is still unclear what their exact extraterritorial implications will be, the question remains to what extent they can actually resolve the debates that I discussed here. I will not get into more detail, but wish to conclude by saying that I believe these due diligence laws can provide for new perspectives on the debates about foreign direct liability claims, but that they will not necessarily settle them. An important aspect that may complicate matters is the yet unclear connection between due diligence and how to establish liability. So in order for the due diligence laws and the foreign direct liability claims that might be based on them to address systematic injustices, render litigation effective, while taking into account the different interests at stake, it will be very important to monitor how understanding of these due diligence norms will develop, who will get a say in their application, and how they interact with other laws in place, both international and national.